सेव किया था ना?
मैं सिर्फ इसलिए गया था क्योंकि उसने मुझे कॉल किया, that's it. But listen तो.
Save it for someone else.
जिंदगी में सेव करना जरूरी है, मगर जब बात पैसों की हो, सिर्फ सेविंग से काम नहीं चलेगा। इक्विटी म्यूचुअल फंड्स में इन्वेस्ट कीजिए और अपने सेविंग्स को आगे बढ़ने का मौका दीजिए।
Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
Former Chief Justice of India Ranjan Gogoi is back in news because of something that is said in Parliament. He became an MP almost 3 years ago, has not spoken a word since then. But now he spoke for the first time. He spoke on the new law, that is the Government of National Capital Territory of Delhi Amendment Bill 2023. That is the bill that converts the ordinance issued earlier by central government into a law, whereby central government takes control over Delhi government in most areas, in most administrative and executive areas, through the Lieutenant Governor of Delhi. And that is the law that came up for debate. And as former Chief Justice of India, Ranjan Gogoi, had good credentials to speak on it, he spoke. Remember, he's a nominated member. As a nominated member, formally, he does not belong to a party. And he's a former Chief Justice of India. So he spoke up and he said something very interesting. Besides whatever he might have said about the bill being debated, he said something on where the opposition to the bill is coming from. The opposition is coming basically from the argument that the bill is violative of the basic structure of the Constitution. So what is the basic structure of the Constitution? We'll talk about it in a minute, but first let's look at what did Ranjan Gogoi said. And when I say this, you'll find visuals of him speaking on the other side. I will also share with you, with the description of this video, a link to what he said. So he said, and I quote the exact line, he said that the law may not be to my liking. That is the Delhi law amendment. The law may not be to my liking, but it is not arbitrary. Does it violate the basic structure of the Constitution? I have to say something about the basic structure. There is a book of former Solicitor General of India, T.R. Andhyarujina, on the Kesavananda Bharati case. Having read the book, my view is that the basic structure of the Constitution has a very debatable jurisprudential basis. I would say no more than this. As he said this, there was loud thumping of the desks from the Treasury side. It's almost as if the BJP people were endorsing the idea that the basic structure was actually debatable. There were also wide smiles, and I saw wide smiles everywhere, and you can see these in the visuals that run on the screen. You can see wide smiles coming in from the chair, that is Vice President Dhankar, but you also see a wide smile from PT Usha, again a nominated member, sitting next to Justice Gogoi. That said, I thought this is a good time for us to look at what is the basic structure, where did the idea come from, how has the idea been used, how useful it is, and does it have a jurisprudential basis, and if so, how debatable it is. So usually you will find that I sit here and I give you 20, 25 minutes, sometimes even 30 minutes of monologues. And I know many of you will say you are not fed up of that, but I understand that you also need to hear from real experts. And that's why I have for you Bhadra Sinha, who's our editor for legal and judicial affairs, and Apoorva Mandhani, who you are familiar with also because she hosts Headlines Ke Piche that we do in Hindi, where I answer your questions in Hindi once a week. That comes out on Sundays. But between the two of them, you are also familiar with many other shows that they do. For example, Know Your Constitution, Laws of the Land, and many others. So once again, an idea. You might think that I sit here and give you gyan on all kinds of things and I must be such a big gyani. I am not. I give you that gyan because people like these, we have a lot of in our team. We have a fantastic team. We have great people in various domains, and I get the gyan from them and I borrow that gyan from them, or they read up stuff and they give me readings or shortlist stuff for me and I read up from that. and I then become the purveyor of that gyan to you. So today, instead of my picking their brains and coming in digested information to you, I thought a better idea is to have them both with us. So first of all, Bhadra, what is Justice Gogoi saying when he says this has a debatable basis, basic structure is a debatable basis, and where does the basic structure come from?
So, Shekhar, basic structure is actually a judicial principle. It was kind of laid down many years ago in a very significant ruling titled the Kesavananda Bharati case. And what exactly is this doctrine about? It basically says there are certain fundamental features of the constitution, such as democracy, secularism, federalism, and the rule of law. Now, these basic features of the constitution cannot be amended. They cannot be altered by the parliament. See, as far as a constitution is concerned, the parliament has the power to amend it, and it has amended it multiple times ever since it came into existence after the independence. Some of these amendments went to the court. They were challenged by various different parties, and that is how this principle of basic structure was evolved by the judiciary itself. Now the debate, which is, now, it's become a center of debate. Why? It actually all started with the vice president, Mr. Jagdeep Dhankar coming.
Who's actually very successful senior
advocate of the Supreme Court, yes, and a very legally very sound person. So he, for the first time, actually spoke about basic structure, and that is how the debate has begun around it. Now, according to him, basic structure doctrine is not mentioned anywhere explicitly in the Constitution. And he says that this principle has been created by the judiciary. So it is like it's a creation of an institution which has no basis in the Constitution, and that is why questions can be raised around it. Now, interestingly, although this doctrine for the first time was mentioned in the Kesavananda Bharati judgment in 1973, but before we talk about more on this judgment.
That was exactly 50 years ago.
That's right, 50 years ago. Yeah, in fact, it was 1973. That's right, 50 years ago. So, but...
And to get the perspective right, historically, 1973 is when Mrs. Gandhi is leading up to the emergency. It happened only 2 years later, but her bit of authoritarianism has started because India had a post-war economy. 1971, we won the war, but the economy was badly crippled. War is very expensive, even if you win it. And then in 1973 came the Yom Kippur War and the oil shock. OPEC was formed and global oil prices boomed. India, after many years of good harvests, had a bad harvest. So Green Revolution, while it was intact, but India was still an agricultural economy. Prices were going up, and she was under a great deal of stress, and these public protests had begun to start, which ultimately led up to the emergency in early 1975. So it was in that period that this judgment came. So tell us more about it.
So before we talk more on the Kesavananda Bharati judgment, I would just like to give a very brief background as to how, the sequence of events that led to the Kesavananda Bharati judgment. So for the first time, this... I won't say that it was exactly a part of this judgment, but yes, the idea about basic structure came into existence, and this was way back in 1951 when the Supreme Court delivered a judgment in Shankari Prasad case. Now, this judgment actually came soon after the first amendment was made to the Constitution.
That is in 1951
itself. 51 itself. So what had happened was that, in this particular case, the first amendment, which actually provided the means to restrict freedom of speech and expression and validation of the zamindari abolition laws, this was questioned before the court in this particular judgment. Now, the moot question that was raised before the court was whether the fundamental rights could be amended under Article 368. Now, 368 of the Constitution actually lays down the procedure for amending the Constitution. Now, as far as this case was concerned, it kind of very briefly discussed about the power of amendment, but it said that yes, the Parliament can actually amend the fundamental rights chapter of the Constitution, which is the part 3, I think, Apoorva,
Right.
yes. And it went on to uphold the Parliament's power to amend the fundamental rights. After that, another interesting case came to the Supreme Court, and I would say that this case actually laid the foundation for the basic structure doctrine, because for the first time the Supreme Court in as many words talked about basic features of the Constitution, and this case is called the Sajjan Singh case, which was delivered in 1965. So in the Sajjan Singh case, actually the 17th constitutional amendment was challenged. The 17th constitutional amendment, which was done by the Parliament in 1964. Now, what did this amendment actually do? This amendment modified a very crucial article in the Constitution called Article 31A. So, as I've told you, most of these challenges were made to the amendments in the Constitution. Now, this particular amendment, as I said, modified Article 31A.
What does Article 31A mean? What does it say?
This actually, through this amendment, it prohibited the acquisition of land used for personal agriculture unless a price equal to the property's market value is paid. So it was basically related to property law. And another amendment which was made was to Schedule 9, which is the 9th schedule, which includes a list of central and state laws that are beyond any judicial review. Means the courts cannot look into these laws that are part of the 9th schedule. Now, interestingly, the majority opinion, this was a 5-judge bench judgment, the majority opinion upheld the amendment. But the minority opinion, which was given by 2 judges, theorized the concept of the basic feature in the Indian Constitution.
They were in a minority.
They were in a minority.
And then we got to a stage where a 13-judge bench.
No, before that, there was one more judgment in the IC Golaknath case, which was an 11-judge bench judgment. Now, in this judgment, interestingly, the minority view in the Sajjan Singh case was upheld, and that became the majority view. So what Golaknath judgment did was, and actually, the confrontation between the judiciary and the government, I must say.
In that case, the Indira Gandhi government.
That's right. This is how the confrontation between the two institutions, began, and it got aggravated. So
that was at the peak of Mrs. Gandhi's power.
That's right. That's right. So while upholding the minority opinion of the Sajjan Singh case, what it said was that any amendment under Article 368 would be hit by Article 13. Now, Article 13 prohibits the Parliament from framing any laws that violate fundamental rights. So what they actually did was they equated amendment of the Constitution to a normal statutory law. That's what they did. Now, this was seen as a severe setback to the Indira Gandhi government, and subsequently the government, of course, through the Parliament, brought in multiple significant amendments to the Constitution. These amendments were 24th, 25th and 29th Amendment, and they indirectly overruled the Golaknath's judgment. Now, these amendments in a way were again made, vis-a-vis the property laws. It kind of curtailed citizens' right over there.
Because an Indian Constitution gives us many liberties, but it does not give us a clear right to property.
That's right. Now, through these...
Unfortunately, if I may say so, because those were times of very socialist ideas. So why should anybody have a right to ownership over property? That's like a fundamental right.
Yeah. So now through these amendments, what Parliament actually did was it differentiated between the procedure in an amendment and an ordinary law. And after these amendments, these amendments, any amendment made to the Constitution, was not required to go to the President. In the sense, the President was not required to refuse or withhold any amendment. So these were the significant amendments. Now, these amendments finally led to the historic verdict, which is the Kesavananda Bharati verdict. And how it actually began was that there was a law which was brought in Kerala. This was passed by the Kerala government. Again, it was a land reforms law, and it was actually framed with an objective to distribute land among landless farmers. Now, the person who actually challenged this law was a seer in a mutt called Kesavananda Bharati.
Like a sadhu, like a
Yes.
like a religious head.
That's right, Kesavananda Bharati. And there's some very interesting facts of this case in the sense that this case went on for 69 days. It began on 31st October 1972.
It was a 13-judge bench. Apoorva, who was heading it?
Justice Sikri, Chief Justice.
And he was a CJI at that
That's
point. yeah.
right. And so the argument started on 31st October 1972, ended on 23rd March 1973, and the judgment was delivered on 24th April 1973. So it was a 13-judge bench, which was headed by Justice Sikri, as pointed out by Apoorva, and it was interestingly a split verdict, 7:6. So 7 gave a majority view and 6 were part of the dissenting or the minority view. Now, what was the contention of Bharati, the main petitioner in the case? What Bharati actually contended was that, these land reforms laws that are being brought up by the government was actually...
Socialist laws.
That's right. It was an attempt to impose restrictions on the management of the mutt's property. So he was more aggrieved about, his mutt property
Personal
being...
grievance.
That's right. It was more of a personal grievance, but it eventually became a very important, significant constitutional issue. And another thing which he said was that these 3 amendments breached his fundamental rights to practice and propagate religion, freedom of religious denomination, including managing and administering its property because it was a mutt, and right to property. So, finally, what happened in the majority verdict was it did not give any individual relief to Kesavananda Bharati. He lost the case. But the basic structure doctrine was laid down through this particular judgment.
So in the 50th anniversary of the basic structure doctrine, now it's being challenged by a recent former Chief Justice of India.
So, Shekhar, interestingly what happened, although the court laid down the basic structure doctrine, but it did not specify what exactly constitutes the basic structure doctrine, So what happened was that eventually it was left to the courts to define it. And over the years, the top court, the Supreme Court has, through its rulings, interpreted this doctrine to include the supremacy of the Constitution, rule of law, independence of judiciary, doctrine of separation of powers, federalism, secularism.
Independence of judiciary, by the way, is the argument based on which the Supreme Court struck down the National Judicial Appointments Commission. And they said this violated the basic structure of the Constitution by violating the independence of the judiciary. So when independence of judiciary became the question, then basic structure was very relevant, and there was no question of this being, of the jurisprudence on which it was based being debatable. But we've seen this often enough in our political system and political history, that people usually fight for freedoms and political rights and fundamental rights only when it begins to affect them and their institution. And very often they are willing to sacrifice other institutions, powers, etc. That's why what Justice Gogoi has now said has implications judicially but also politically. And that political implications come from the fact that when he made this statement, the BJP members were thumping the desks. Otherwise, the BJP's own politics, BJP and Jansangh before that, and the RSS has been built around opposition to Indira Gandhi's authoritarianism, to the emergency, to the awful things she did during the emergency, her suspension of fundamental rights, constitutional provisions, her passing of the 42nd Amendment in the 6th year of Parliament, which was an illegitimate Parliament in everybody's view now because she had extended the term of that Parliament by postponing elections. The first time and the only time such a thing happened in India. That happens in Pakistan routinely, by the way. They've just done one more postponement just now. But in India, the only time, and hopefully the only time forever. And she made these amendments to take away these fundamental rights. And then some brave judges, those brave judges featured in the Kesavananda Bharati judgment, which which defined the basic structure of the Constitution, which has protected the Constitution and our fundamental rights. Since then, and Apoorva will give you many examples of the key cases in which the Supreme Court has invoked the same basic structure doctrine to protect our freedoms. And she will also tell you about the 42nd Amendment and how Mrs. Gandhi had tried to take away all the freedoms of the Constitution and how these were restored. So go ahead.
In fact, with the 42nd Amendment, she also tried to undo the basic structure judgment, which shows that probably Mrs. Gandhi and the current government, they stand on the same side when it comes to not liking the basic structure doctrine as such. But the first application also, since we've been mentioning the emergency, the first application of the basic structure doctrine also came in a case titled Indira Gandhi versus Raj Narayan. This was...
Raj Narayan was the socialist who defeated her in Rai Bareli in 1977. And famously, as election results came in and people went to tell him the results, he was sleeping under, I think it was a peepal tree. It was a very hot summer's afternoon.
Right. This is the judgment that was passed by the Supreme Court a few months after the emergency in November 1975. And this was when right after the emergency, Mrs. Gandhi passed another constitutional amendment, which is the 39th Amendment, to sort of undo the damage that the judgments had done to her election. This amendment, it did several things, but among those things, it took away the power of the court to look into challenges to elections of the Prime Minister and the Speaker. And it also said, this amendment, that any pending proceedings under any law of such a challenge to the election, it will be null and void. And this was the first application of the Kesavananda Bharati judgment, where they declared the amendment unconstitutional on several grounds, ruling several things to be basic structure, including democracy, rule of law, and equality. So that was the first application. Since then, I'll just mention two more judgments which sort of also crystallized the basic structure doctrine as such. The second one was where I'll speak about the 42nd Amendment. Again, it's in fact famously and informally called Indira's Constitution or mini Constitution because of how many amendments were.
So this was basically abrogating the earlier Constitution and creating a new republic. That was the reality.
Right, and several of these amendments were then challenged in Minerva Mills versus Union of India, this 42nd Amendment. There were also several amendments with the 42nd Amendments were undone by the 44th Amendment.
Yes, that was when the Janata Party government came to power. They were committed to repealing these. So they repealed most of this 42nd Amendment and rectified the Constitution and basically repaired the damage done by Mrs. Gandhi. And interestingly, in that repeal, the Congress Party joined in. The Congress Party did not resist that repeal because they also, to that extent, did a mea culpa and they admitted that they had done something wrong. And that is seen as constitutionally and more important than constitutionally, politically a regret for the emergency, for the excesses of the emergency. But even the Janata Party did not repeal some things that Mrs. Gandhi had added through that amendment. And tell us about that.
Just the most popular being fundamental duties, because those were added during the emergency as well, but they still stand.
So fundamental duties in our Constitution were not written in by the founders of our republic, by the people who signed the Constitution, by the Constituent Assembly, Ambedkar's Constituent Assembly. These were added by Indira Gandhi through this wild 42nd Amendment, through an illegitimate parliament, the 42nd Amendment, and these fundamental duties were retained by the Janata Party. And the truth is that today, Prime Minister Modi actually lays great store by them. In a lot of his speeches, fundamental duties come out. Even his Mann Ki Baat talks a lot about duties. I'm not sure I've seen him refer to fundamental duties in the Constitution in his Mann Ki Baat, but he talks about duties. And even in the article that he wrote for the New York Times on the 150th birth anniversary of Mahatma Gandhi, the entire article was based on the idea of fundamental duties. So that's That's one of those amendments which has prevailed since then. That's an aside, not exactly about the basic structure, but because we are talking about important constitutional issues and how they affect not just our freedom, but politics by and large, I thought it's important to mention this as well.
Absolutely,
so go ahead.
because basic structure doctrine is also all about amendments, whether the constitution can be amended in a way which changes its basic features. So anyway, 42nd Amendment, now since I was mentioning, it specifically had a clause which expressly stated that the amending power was unlimited and not open to judicial review.
Yes, so Parliament could amend anything and judiciary will not be able to then scrutinize it. That is the law that Mrs. Gandhi had brought in, that Indira Gandhi had brought in. We've seen since then many other dictators tried to get those powers. Erdogan has tried, Netanyahu has tried, and he's in trouble right now. Putin can make what law he wants, right? And all other strongman leaders want to be like that. In this case, it was a strong woman leader who tried to get these powers. And then the basic structure doctrine it is that prevented such excesses going ahead.
Yeah, it saved itself essentially because the Supreme Court held that the limited amending power of the Parliament was itself part of the basic structure. So that's how the basic structure doctrine was saved. And then there's one more case which sort of crystallized basic structure doctrine. Again, this is the Vaman Rao case, which held that laws placed in the 9th schedule, which essentially takes them beyond the pale of fundamental rights review. It said that they would nevertheless have to be tested on the on the point of basic structure. So it sort of took away that immunity from laws in the 9th schedule, which shields laws from that scrutiny. So those are some of the significant. And then later there were other things that were included, features that were included in the basic structure doctrine, like secularism and S.R. Bomai judgment. So there's a long list of judgments.
So if we come to more recent times, if you look at the benches or the judges that we've seen over the past decade and a half,
right,
in many of which Justice Gogoi himself will feature, right? Many of those benches, including Justice Gogoi's benches, have employed the basic structure doctrine to give their orders, and there they did not find it, the jurisprudential basis of it, debatable.
Right.
And that's why we saw sometimes there is great parliamentary bit which comes out not in parliament but on Twitter, or what is called as X right now. I don't get myself to call it X, but X, which used to be called Twitter, Twitter which is now called X. Manish Tiwari, the Congress MP, said, where you stand depends on where you sit.
Yes.
And he was commenting on a story in the Indian Express that showed that when Justice Gogoi was on the bench, then he employed the basic structure for his judgments, and he found no debate over its jurisprudential basis. But now that he's sitting in Parliament, when he was sitting on the bench, he had one view. Now that he's sitting in Parliament, albeit as a nominated member, he has another view. So some of the major judgments which delivered by benches where he might have featured. So there's the biggest one is the judgment on the petition to bring the CJI's office under RTI. So I told you I will use this constitution or whatever is there, basic structure, no basic structure, to protect my freedom and my institutions. Aap sabka will think about it, right? There might be the basis then for all this may be debatable. So are we getting somewhere there now? Are there other orders that his benches have signed?
There have been actually. I have a few of them here. I can quote them also for our audience. There's one in November 2019 where a Gogoi-led 5-judge bench in Roger Matthews' case struck down the law restructuring tribunals for violating basic structure. And I'll quote the opinion that he wrote.
No, tribunals, this is restructuring of tribunals by the executive,
right,
and they said that government's order or law,
It was a law.
To get power to restructure these tribunals violated the basic structure.
Right.
That's right.
And
the feature of the basic structure which it violated was independence of judiciary.
Once again, I am fighting for myself, na.
Yeah.
It's a perfectly good human value.
Right. So they've spoken about doctrine of separation of powers and judicial domain, and Justice Gogoi wrote that the doctrine of separation of powers has been well recognized and reinterpreted by this court as an important facet of the basic structure of the constitution in Kesavananda Bharati and several other later decisions.
And then the most important of all, the
Ayodhya case, yes.
And what happened in Ayodhya
So
case?
in the Ayodhya case, all the judges, they spoke about the majority verdict. They spoke about secularism as a basic structure, as a part of the basic structure doctrine. And then they spoke about the Places of Worship Act 1991. Just to tell you a bit about this law, it freezes the religious character of any religious place of religion as it stood on 15th August 1947.
Except Ayodhya, which was already in court when this was passed. And then the destruction of Babri Masjid took place, and then the rest of, you are more familiar with whatever happened. Finally, this case was settled by the Supreme Court. On that order, we had done a full episode of Cut the Clutter. There, in that judgment, the court said, the bench said, that now, basically they said that no place of worship can now be similarly affected, because there is that law passed by Parliament, and they placed that law in the basic structure to give that law some protection.
Right.
Basically, that law was, the Places of Worship Act was actually promulgated with an objectivity to maintain secularism. And since secularism is part of the basic structure of the Constitution, so automatically this law is also finds its space in the...
So to understand the political implications of this, now that the Varanasi controversy is going on, and you know, Mathura controversy sort of waxes and wanes. At some point, it is going to wax again. It will rise. In these cases, the defense from the other side is Places of Worship Act. And Modi government or any BJP government, because BJP did not vote for this law, so they would like to amend this law or repeal this law. What comes in the way right now, and that's politics, what comes in the way right now is that in the Ayodhya judgment, the Supreme Court positioned this law in the basic structure of the Constitution. So if you want to get rid of this law, as I'm sure a lot of people in the BJP would like to, and a lot of people on the Hindu side, anyway, BJP or not, would like to, then they have to first demolish the doctrine of the basic structure of the Constitution. That is the politics. So my job on this panel is to interpret the political implications of what's going on, or political meaning of what's going on. Judicial stuff, these two experts tell us. So Apoorva, so that judgment, that particular judgment, again, Justice Gogoi was a signatory.
Right. He was a signatory to the judgment, and
In fact, he headed the bench.
He headed the bench.
He
Yes,
headed
and
the bench.
after that there was a famous
The
dinner and a
photo.
good
That's
photo.
right.
Yes.
Yes.
So that's exactly what happened in the case. They said that the law is an instrument. It said that a legislative instrument designed to protect the secular features of Indian polity, which is one of the basic features of the Constitution.
So having said that, I will now conclude. I know this is a particularly long episode of Cut the Clutter, but I also have very smart people with me to explain very intricate issues for you. Very intricate, because this is where judicial issues, legislative issues, and political issues, but most importantly, issues so critical to our liberty and our fundamental rights, all of them intermesh. So thank you very much for your patience. I will conclude this, if I have the permission from both of you, if the bench permits. I will conclude this with a quote from Justice Gogoi's speech, and I take it from the Indian Express story today. Justice Gogoi's speech at the 2018 Ramnath Goenka Memorial Lecture 2018 on July 12, where he said, basic structure is an example of very sound jurisprudence. Basic structure is an example of very sound jurisprudence, not debatable, very sound jurisprudence, which we continue to reap from. And then he goes on to say how this evolved, the basic structure doctrine evolved from 1970 to 1980. Then 1990s onwards, the Supreme Court expanded this and also expanded the scope of Article 21. So tell us, what's Article 21?
It's the right to life and personal liberty, and the courts have held the right to include several other rights, like right to livelihood and right to fresh air. So
Right to privacy, which was the Puttaswamy judgment.
Right.
That's like the most significant ruling. Right to privacy has been made a part of Article 21.
Right. And then he said in the same speech that how this has made the Supreme Court of India the court of good governance court, and wherever it sees lacunae in the functioning of the executive or parliament, the court moves in, and that has enhanced the power of the court. I mean, now he finds it debatable that, but people can change their minds. John Maynard Keynes said, I change my mind as facts change. What do you do, mister? Isn't it? This jurisprudence, while he sat in the court, was sound. It was an example. It was a wonderful thing. It protected so many things. And now he finds the very basis of it. The jurisprudential basis which he found sound is right now debatable. So once again, I refer you to Manish Tewari's tweet, where you stand depends on where you sit. On which note also, thank you Bhadra, thank you Apoorva. You brought in so much more wisdom and also saved me so much trouble for having to read up and mug up everything. Thank you very much. Also, sometimes I get some questions from wonderful people like you saying, how come we have so many women featuring on our shows? I will tell you one fact. Our newsroom is 85% female, 85% female, and there is no affirmative action. In fact, we are quite willing to offer an affirmative action to men to come in to restore the gender balance in our newsroom. It's just that women are so much smarter than us men.